In this lesson, what we're going to do is take an introduction to the concept of criminal law. And we're going to be talking less about legal principles, but more about the theoretical principles that underpin the legal principles that we will go on to discuss later on. So, in this lesson specifically, we're going to look at really what criminal law is. How do we define criminal law? How do we know that something is a crime? What is the criteria for establishing something as being a crime? We're then going to look at the concepts of criminalization and justification for criminalization. Why is it that how is there a justification to criminalize some acts? And then we're going to look at the distinction between a real and a regulatory crime and the arguments for separating the two. There are some arguments to suggest that the two should be separated. So let's begin by asking ourselves, what is criminal law? Well, ultimately, the study of criminal law is the study of the kind of things that make up specific offences. So it also studies the underlying principles by which these offences are interpreted. When we look at criminal law, we tend to examine things like mens rea and actus reus, these kind of Latin words that underpin principles of criminal liability. And we often describe and talk about things like mens rea and actus reus almost vicariously through the lens of specific crimes. So we talk about the mens rea and the actus reus for things like murder, manslaughter, etc., etc. Criminal law isn't necessarily the study of criminal procedure or criminal evidence. These are still tangentially related to criminal law. They are, there is obviously some relation to the criminal law, but these are things that make up entirely different courses on their own. The concept of criminal procedure and the law of evidence are both two pieces of law that can have their own set of lessons. So they're not going to be covered in this course. So we understand that criminal law is the kind of things that is the study of the things that make up criminal liability and the study of what makes something a crime. So how do we know something actually is a crime? Well, in law there are two kinds of legal procedure. You have a criminal procedure and a civil procedure, and to that extent there are by extension there are two kinds of modes of coming to different legal conclusions from a criminal perspective and from a civil perspective. In a criminal case, there is a specifically different procedure that takes place, and this is one way in which we can delineate crimes from other things that take place within law. This is one way we can know that something is a crime. So, as Williams in 1955 described it, a crime then becomes an act that is capable of being followed by criminal proceedings. So what he means here is that a crime is just anything that once it takes place, we can and then enact criminal proceedings against the individual that committed whatever it is that took place. And that's how we can define crime. The question really is that a very good definition? Because what we're doing is defining crime by the procedure that takes place immediately after whatever it is that happens. Is that actually defining what a crime is? It seems to be a very surface level approach. It seems to be a very surface level way of trying to define crime as just anything that requires a criminal proceeding. It doesn't really tell us anything about actually what is a crime, what distinguishes a crime from something else, except for procedurally what is a crime. So a response to that is that in some cases you can have a particular act that can be wrong both through a civil perspective and also through a criminal perspective. So if we're going to define a crime as anything that it follows that a criminal procedure then follows, then by that extension, how do we respond to cases where something can be both civil wrong and also a criminal wrong? Take, for example, the act of assaulting someone. That can both be civil, the person could then sue for damages, and it can also be a crime. It can also be criminal. So some note that there is a difference between civil and criminal in this response. So a civil claim is one that is completely different in nature to a criminal claim. For the case of a criminal claim, an action is criminal because it is an action that takes place between the state and a private individual. By contrast, a civil case is one between two private parties, or two or more private parties. So, in a criminal case, the victim of the crime is placed away from the proceedings, and the state steps in. So, in a civil case, if someone was to assault you and you wanted to sue for damages, that is your choice. You have the choice to sue for damages, and then you become the claimant within that civil case. In a criminal case, things are very different. The victim isn't the one that's bringing forth action against the individual that committed the offence. The person or the individual or the thing that is bringing a claim against the individual who's committed an offence is the state. The state is involved, and the victim takes a backseat approach. Okay, this almost removes a certain amount of agency from the victim in a criminal case, and the kind of agency that doesn't actually exist in a criminal case, as does a civil case. Generally, a victim in a criminal case, they are reduced to that of a witness. So they are called as a witness. So this is one way in which we can define the distinction between crimes and criminal cases from that of civil cases. Another way we can look at it is ask ourselves the question of whether or not a crime can be described as a, quote, public wrong. Okay. It's a very interesting question. Beyond being a wrong done to a particular victim, to a particular person. So, for example, if a particular person was to murder somebody else, well, we know that a wrong has been done to that particular person. They've been murdered. But can we define crimes more broadly as something that is wrong from a public wrong to the public? So Blackstone argues that besides the injury done to individuals, crimes strike at the very being of society, and this is an implication of representing crimes as a public wrong. One can define crimes as wrong that are not just directed to the victim, but also wrong because they impact the public as a whole. And by that we mean that if crimes are left without any kind of punishment, then society would not be able to persist. So it's not just wrong to the particular person who has been murdered, okay? It is also a wrong to society, because if we were to not bring about criminal proceedings against that individual, then or any individuals that committed murder, then a society would not be able to persist. A fully functioning society cannot exist when we have crimes being committed without due process, without any kind of punishment taking place. So this implies that crimes are at least somewhat public wrongs. They are wrongs that strike at the heart of society, not just a particular person. They also concern the public as a whole, since society would suffer if crimes go unpunished. And this brings us into the question of criminalisation. Criminalisation is obviously a heavy philosophical topic, just like everything else that we've talked about in this lesson. What does it mean to criminalise a particular conduct? So, criminalisation involves a prohibition. So, it is involving, if we are to criminalise a certain act, we are setting out a set of rules relating to a thing that should not be done. So, if we criminalise something like, murder, we use the most, the heaviest example, we are setting out a set of rules, okay, that tell us, that inform our actions. They tell us that we cannot perform these things. There is a prohibition on these things. The criminal law prohibits one from, say, shoplifting as well. That is an act that is criminalized. If someone transgresses and does commit the prohibited act, then a process is set in place to convict the individual. And so this is the concept of criminalization. We have it exists along two planes. We have the process of prohibition of a particular act, and we also have a conviction process that takes place if one was to transgress this particular act. And then once convicted, we have the third stage, which is the punishment of the individual. Just don't forget that when we talk about criminal law and criminal procedure, something that's again tangentially related, we have an act that takes place. We then have a process in place to try the person who committed the act, and then to convict them, and then to find them guilty of the particular act once, or not guilty if that may be the case. And then once found guilty, once we have conviction, the criminal law then sets out the punishment of the said individual. Now, this punishment can exist in a variation of forms. Again, criminal punishment is also a different kind of question that is tangentially related to criminal law. We have things that can go from anywhere from fines and community service and things like that, all the way up to imprisonment. Arguably, imprisonment is obviously the heaviest punishment that one can receive, because we don't have any kind of capital punishment these days. And there is also the expectation that when we have punishment and we put punishment in place, the state enforces a punishment against an individual who has committed an offence, there is also the expectation that the punishment be proportional to the seriousness of the conduct. Ashworth notes that the determination of seriousness should be a very important factor in the implementation of criminal law. He suggests that, in principle, the criminal law should not be used against, quote, non-serious wrongs. This is in his an article written in 2000 called "Is Criminal Law a Lost Cause?" And really what we are getting at here is the proportionality should be something that is very important. So, for example, if one was to commit a rather minor offence, so for example like a road traffic offence or something like speeding, then there is the expectation that the punishment for that offence is proportional to the offence itself. Now, you wouldn't expect in a reasonable society that somebody who commits a minor crime, a minor offence, be sentenced to the most extreme punishment, things like 25 years imprisonment. Equally, you wouldn't expect the inverse to be true. Somebody who is convicted of murder there would not be the expectation that they would only receive a fine for that offence. There has to be a certain level of proportionality. And this brings us on to Ashworth specifically, because Ashworth did suggest that there is ways in which we should be able to justify the use of the criminal law. The criminal law should not just be used arbitrarily. There should be a certain set of criteria that we can use to justify criminalisation. And there's really 5 key factors that are at place that Ashworth notes. The first one is the behaviour sufficiently serious to merit intervention from the criminal law? Now, from a philosophical perspective, some people argue that something should be a crime because it causes harm to an individual or a set of individuals, etc. However, the counter argument against that is we have a number of things in society that are perfectly legal and perfectly fine to do, okay, that are nonetheless harmful to an individual, or nonetheless are immoral. This also brings into question the concept of legal moralism. Is the criminal law supposed to be a reflection on societal morality? Because in that case, would we be able to punish people from using the criminal law for example, cheating on their significant other? If that is a case that we could, we're not, without getting into the weeds of philosophy here, is arguably a very immoral thing to do. But is it sufficiently serious enough to merit intervention from the criminal law? So that's the question for philosophers out there. The second point is, could the act be dealt with under any existing legislation? So before we start to think about criminalising something else, we start to create new crimes for people to have to follow. Could we deal with this act in any other kind of legislation or any other kind of regulation or any other kind of way? Is there another way in which we can prevent this act from taking place without having to intervene with the criminal law? The third point is the crime enforceable? Because there is the argument to be had that in some cases that something can be a crime, but it's so difficult to enforce that it's basically ineffective. It becomes pointless to even criminalize an act that is so impossible to enforce. Some people, from a political perspective, arguably, have made the argument that the COVID restrictions and the lockdowns, were unenforceable. And I guess to an extent, in some cases, they might be. Because we've all been in the situation where you could arguably suggest that it's very difficult to enforce a crime such as breaking lockdown regulations. Even if we're talking especially in like very minor cases. So obviously, this is something that has to be taken into consideration. If it's something that is that you would want it to be a crime, but it would be impossible to enforce upon everybody, then it becomes impossible to justify criminalizing that behavior. The fourth point is, can one clearly define and prescribe the exact conduct that ought to be criminalized? There's no point in trying to criminalize something and trying to define a crime in a very vague, wishy-washy kind of way, because that's not going to help anybody. How can people be rationally and reasonably expected to follow a particular code of conduct, specifically the criminal law, if they cannot, if it's actually vague what they are supposed to be doing? So you have to be able to clearly define and prescribe the conduct that ought to be criminalized. And then the final one, which we have talked about already, is the punishment proportional to the seriousness of the offence? If we can check yes to all of these 5 points, then we have a justification to criminalise a certain act. This is according to Ashworth. Finally, I want to touch on the concept of real versus regulatory crimes. In some cases, criminal liability is imposed by Parliament not as a means general, not as like the goal isn't to catch criminals, except for example, but generally as a means of regulating activity. So in these cases, they are often aimed at avoiding harm rather than punishing harm that has already been caused. So a very good example of this is health and safety legislation. The purpose of health and safety legislation is to try and direct societal behaviour in a way that avoids harm, to try and regulate behaviour to avoid harm that is caused as a result of that. However, despite the aim of regulating behaviour and trying to prevent harm, they still may incur real penalties and punishment if breached, which is why we would define them as regulatory crimes. And this brings about another theoretical question. Should the criminal law be used in the way that lumps regulations in with real crimes such as rape and murder? Because you've arguably got a disparity here. Health and safety legislation is generally just there to try and regulate people's behaviour in a way to, be better safe and to prevent as much harm as possible. Is it really fair? Is it really necessary to lump that kind of regulatory crime in with a much more serious crime such as rape or murder? Well, obviously, the concept of the criminal law has to exist on a spectrum of seriousness, because even if we take out regulatory crimes, we can still think of crimes that are definitely less serious than rape or murder that still exist along the same plane as those serious crimes. So in conclusion to everything that we've come to, in this lesson what we've done is introduce the concept of criminal law, try to define it in a way that, in at least an acceptable way, and I've tried to give a number of different perspectives from a philosophical perspective and a theoretical perspective. We've looked at how we can define criminal law and how we can define crimes more specifically. We've then examined some of the philosophical issues around the concept of criminalisation and justification for criminalisation, how we justify making a particular act criminal. And we've also finally looked on the concept of real versus regulatory crimes. And then in the next lesson, what we're going to do is talk a little bit more about a number of other little key philosophical underpinnings before we start beginning the process of examining the concepts of what makes what is required legally to bring about an action that is criminal in criminal liability.